with the law firm of Meyer Newstanek. He is a graduate of the University of Minnesota and Stanford Law School and is certified as a senior civil trial specialist by the Minnesota State Bar Association. In addition to his law practice, he is an avid historian and educator on constitutional law and history. So please help me welcome Marshall Tanek.
Thank you for that very nice, kind introduction. Appreciate having the opportunity to be here today. And it's remarkable the turnout, considering the fact that CLE reporting isn't until next June. So very nice turnout. For those of you who are particularly interested in this topic and want to hear me again in a little bit different context, I will be giving a version of this, a little bit different format tonight at the St. Paul Jewish Community Center to the Jewish War Veterans. So if you can't get enough of this or we run out of time, come to the JCC tonight at 7 o'clock for more of World War I. This is obviously a very timely subject, what with the 100th anniversary of the ending of World War I being last Sunday, an armistice date at that time. And my goal here is to review some of the case law, largely from Minnesota State Court, Federal Court, and even Supreme Court case, United States Supreme Court cases, dealing with issues that were affected by World War I or affected World War I, as well as trying to trace through how some of these cases and the doctrines in these cases affect the law and affect us today in our daily lives, and show how the pattern has emerged over the past century. Switch here. Oh, is this right?
There you go.
Okay, this is working now?
Yes.
All right. We have passed out some articles I've written about the topic, which largely cover this material I'm going to be talking about. But so feel free to delve into the articles I've distributed as well. As far as questions or comments, feel free to pipe up whenever you want during the course of my discussion, rather than saving them for the end. Since this is the 100th anniversary of the end of World War I thought I'd start by taking a look at some figures relating to centenarians and 100. As of the most recent count, there were approximately 450,000, I think it's probably closer to 500,000 worldwide centenarians, people who are 100 years old or older. All of them would have been living, although probably not remembering, the armistice of November 11th, 1918, about 500,000 in the world now. In the United States, there's about 75,000 people who are 100 years or older. Figure there's a few years dated. And probably by the time we get to the 2020 census, it'll be closer to 75 or 80,000. There's been a huge increase, as you can see, in the number of people who are 100 years old just over the past couple of decades. Of the centenarians, 17% are men, 83% are women. Not surprising, women have longer lifespans generally. In the United States as a whole, 0.22% of all Americans are 100 years old or older. When I gave this, I gave another version of this presentation a couple of weeks ago, and one of the people shot their hand up and said, "You mean to tell me that 22% of the people in the country are 100 years old?" I said, "No, you got to read the decimal point. It's 0.22, okay? 0.2% of 1%, so about 1 out of every 500. And that's in Minnesota, we have about 1,500 centenarians. I know it says 1,200 there. That's the 2010 census, probably closer to 1,500 these days. They're closer to 1,500. And interestingly, the number of Minnesotans, or the percentage of Minnesotans who are 100 years old or older, tracks the national statistics as well. 0.23, right? 1/5 of 1%. Okay, so that's the some figures there. Some more numbers here. Casualty count from World War I. 36 million worldwide are considered casualties of that war. 20 million died. Not all people in service. There were civilian deaths attributed to World War I. 20 million deaths. 16 million wounded. Of the Americans in World War I, we had about 4.7 men and some women in military service. Thank you for your military service. And 330,000 of them were casualties, approximately, roughly 320,000, 330,000. There was a little over 115,000 deaths attributable to World War I for American in the military, and about 210 to 215 wounded in the war. Close to between 320 and 330,000 Americans suffered casualties in the war. As far as Minnesotans, a little bit of uncertainty or controversy there. Some of the research on the internet, at least, which is the place to do most research that I do these days, it gives figures of 100,000 Minnesotans were estimated to be in military service during World War I. 100,000. However, the plaque on the state capitol grounds here, which some of you may have seen, there's a large Vietnam Wall there, World War II memorial, small Korean War memorial. There's a small plaque on the Capitol grounds toward the, I think it's the Stassen building on the other side, down the mall there. And I don't know if you can see it real well, but I don't want to do that. The plaque there says that it is World War I is dedicated to these 57,413 Minnesotans who gallantly served in the war to end all wars. One of the names that was prescribed to World War I, some called it the Great War back then. 57,415 are ascribed as being Minnesotans in service during World War I. That figure conflicts with the 100,000 estimate. It also conflicts with article in the Star Tribune. This was Sunday, and one of the columnists there, Jennifer Brooks, was a fine columnist, wrote a piece on Minnesotans in World War I, a kind of retrospective piece about Minnesotans in World War I and commemoration of Veterans Day. And she says in her piece, Jennifer Brooks, 118,500 Minnesotans served in World War I. I don't know where she got that figure. Twice the figure that's on the monument there at the Capitol grounds. At any rate, the number of those killed in World War I is not in dispute. The historical records and other records indicate that approximately 1,400 Minnesotans died in combat in World War I. But a greater number, 2.5 times that number, died as a result of or during the great flu epidemic that came after World War I, and as most of you know, that was a worldwide pan-epidemic of flu that was very devastating, and both in this country as a whole and in those in the military service suffered greatly casualties as a result of the flu epidemic. And we, at least as far as Minnesota, 2.5 times the number of Minnesotans who died in combat died as a result of the flu epidemic, which stemmed from World War I. Let me pause for a minute and ask if anyone here has any particular relationships to World War I, either familial or other relationships. I find that many people do. They've either had parents or grandparents or other relatives serve in World War I. Is there anyone here who has that kind of relationship with World War I on a more personal or family level? You want to tell us just briefly about it? Okay. Yeah, right. For those who can't, your grandfather was training at Parris Island, South Carolina, right? When World War I, during World War I, he didn't get called. He didn't get called abroad, sent abroad, deployed abroad. But okay. Anyone else have any particular World War I tales, stories, relationships? A few just historical decisive dates in connection with World War I. The triggering event of World War I, as most of us know, was the assassination of the Archduke Franz Ferdinand. The Archduke was the heir to the Austrian-Hungarian Empire, something that no longer exists, but it was Austria-Hungary had a huge empire in the central part of Europe for centuries. And it was in the early part of the 20th century, 1900s, and even before then, it was torn apart by nationalistic and tribal rivalries. And the Bosnians and the Serbs and the Slavs who were not getting along well, that was boiling over in the early years of the 20th century much as it did in the early years, the later years of the 20th century, and even into the 21st century. And a Serbian nationalist by the name of Gavrilo Princip assassinated the Archduke, the heir to the Austrian-Hungarian throne. That essentially triggered World War I. However, while the history books indicate that that was the triggering event, and it was, the war did not come about real suddenly. There was a buildup, there was animosity and adversity between largely the Germans and the British leading up to that. The Germans had tremendously increased their naval forces, basically seeking to contest the British control of the seas. And there were rumblings, if not of war, certainly of events leading up to the war, preceding that event in 1914, the assassination in June of 1914. And as a result of that animosity and adversity that was building up between largely Germany and Britain, and even going back before then, the European countries, many of the European countries, as you know, had entered into treaties. And it was the existence of those treaties that while the assassination was the trigger for World War I, the existence of those treaties provided the ammunition that led to World War I, because after the assassination of the Austro-Hungarian royalty, the war, 6 weeks later, Germany declared war on Russia, and that was technically the beginning of World War I. It was Germany declaring war on Russia, essentially blaming Russia for inciting the difficulties that led to the assassination of the Austrian-Hungarian royalty. So Germany declared war on Russia. As you know, Russia had treaty with Britain, and some of that is related to the familial relationship. Queen Victoria was related to the Romanovs, the dynasty in Russia at that time, and they had a long-standing treaty that predated the war. And Britain and Russia had a treaty: if one of us get into a war, primarily with Germany, because that's what they were thinking, the other will come to their assistance and aid. So it was the existence of the treaty between Russia and Britain that brought Britain into the war against Germany. And France had a treaty with Britain. France and Britain are age-old adversaries, but France and Britain had a treaty. France's treaty was, if you go to war, we'll go to war. Britain's treaty was, France, if you go to war, fearful of the Germans, we'll aid you. So but within days, we have Germany declaring war on Russia, England and France then joining Russia and declaring war on Germany, and vice versa. Italy also got in at that point because Italy had a treaty with Germany. And Italy entered the war on the German side, and as it did in World War II, Italy exited from the war and switched sides in the middle of the war. But at the beginning of the war, Italy was on the side of Germany, and there was some, very minor, some World War II fighting that took place in the Pacific, nothing like World War II. But Japan also was linked to a treaty with Germany, so Japan was on the German side in World War II. Again, it was certainly not anything like the Pacific theater of war in World War II, but there were some skirmishes in the Pacific because Japan was on Germany's side in World War I. The war pressed on for several years before the Americans entered. The American policy, as articulated by President Woodrow Wilson, was neutral in thought and deed. America wanted to stay out of the war, and the official slogan, the official terminology used by President Wilson's administration was be neutral in thought and deed. However, there were tremendous pressures exerted on the United States government as well as the public to get into the war on one side or the other. Britain had a lot of propaganda here in this country trying to bring America into the war on Britain's side. Largely through newsreels, the social media of the day. There was a relatively well-known newsreel that was called The Rape of Belgium, in which the British tried to portray the Germans as being amoral and immoral and trying to stir up American favoritism toward Britain. The Germans likewise had propaganda here trying to either keep the Americans neutral or get them on the side of the Germans, which probably wasn't going to happen, but at a minimum, the Germans wanted to stabilize the United States and keep them out of the war. And we did stay out of the war, but there were several incidents that brought us into the war. One of them was the sinking of the Lusitania, and it's a pretty good book written about that. Some of you may have read it by Eric Larson called Dead Weight. It's a story of the sinking of the Lusitania, but it's also more about equally about the events leading up to World War I and what was going on in the world that caused the Lusitania to be sunk. It was sunk by German U-boats. The German U-boats patrolled the North Sea, fighting the British, who still had probably a better naval force than the Germans, and the U-boats were very active in sinking cargo ships and other boats that were trying to bring war supplies to Britain and to France. The U-boat sunk the Lusitania, which was a ship carrying cargo to and from, taking cargo to and from the United States or Canada, actually not from the United States, but from Canada to Britain. But there also were a number of civilians on that on that boat, and 2,000 people were killed in the sinking of the Lusitania. 2,000, that's a huge amount, much more than the Titanic. It was actually bigger than the Titanic. And 114 Americans were on the Lusitania and were killed when that was sunk by German U-boats. It created a great U-boat. It created a huge stir of anti-German feeling in this country, but still we stayed out of the war. In 1916, Woodrow Wilson ran for re-election. He ran against Charles Evans Hughes, member of the Supreme Court. And Hughes was the Republican, of course. Wilson was the Democrat. The Republicans were much more aggressive in wanting to get into the war. Theodore Roosevelt, who was still a renowned Republican spokesperson at that time, was very aggressive trying to stir the United States to get into the war on the side of the British. And generally, the Republican Party and the Republican approach was, we probably ought to get into the war. They weren't saying that we ought to, but they were leaning in that direction. Wilson's position was different and quite different. And Wilson's campaign slogan in 1916 was, "He kept us out of war." That was the Wilson campaign slogan. Okay? Just like all the way with LBJ and the Morning in America and Make America Great Again. The Wilson slogan was, "He kept us out of war." And the election of 1916 largely, there were other issues, but largely turned on whether the U.S. should enter the war or not enter the war, which had been going on for almost 2 years by that point. And the Republican Party generally wanted to get into the war. The Democratic Party, led by Wilson, let's stay out of it. Wilson barely won that election. The election returns back in those days came in almost as fast as they do these days, and they didn't have hanging chads and social media and all that. But the election results in those days would come in by the end of the night, they declare a winner, maybe the next day, not in 1876 with Rutherford B. Hayes and Samuel Tilden, when it took months to get that result. But generally, the election results were known within a day or two. Right? In that year, it was so close that no one quite knew who had won. Wilson went to bed that night thinking he lost. The electoral count was against Wilson as of when the evening ended, midnight, 1 o'clock. Wilson went to bed thinking he lost. And some of the early newspapers, although there's not ones of those Truman holding up the Dewey beats Truman, but nevertheless, the early press reports were that Wilson lost. The California vote was critical. The California vote came in late in those days. California in those days was predominantly small towns, small communities, a lot of mining communities and ranches. Los Angeles wasn't, the Southern California wasn't the Southern California we know of today. It had 200,000 people in Los Angeles. Minneapolis was bigger than Los Angeles. So most of the California vote was scattered among small little hamlets, mainly in the northern part of California. Southern California wasn't that well developed, or in the ranches and the valleys of California. That vote came in real slow. And 2 or 3 days later, when that vote finally trickled in, Wilson won California. And that was enough to put him over. Wilson was declared the winner about 3 or 4 days after the election. So Wilson squeaked out a narrow victory in that election. Let me just back up a minute. Another key event that was leading up to war was the notorious Zimmerman Memorandum. That was about a year later. That was right before the presidential campaign in let me back up. That happened right after the election. Wilson gets reelected in 1916. And within 2 months is the Zimmerman Memorandum. Wilson's position is still neutrality. And the Zimmerman Memorandum, as many of you know, is considered to be a major provocateur for the American entry into the war. There were other things going on there, but as of the turn of the year, January 1st, 1917, our position was official neutrality. In early January, there was a leak to the media of a telegram. Today it would be emails and texts from the German ambassador to the United States, to his counterpart in Mexico. And at the time, there was some speculation that it was fraudulent or forged. Turned out it really wasn't. The history has indicated that it was an authentic memorandum. And basically, the German ambassador was beseeching the Mexican ambassador and the government of Mexico to either stay out of the war or possibly even enter it as an ally of Germany. And the quid pro quo was, if you folks in Mexico, if Mexico will stay out of the war, or perhaps even join us, join the Axis powers, join Germany in the war, we may help you after the war get back some of that land you lost. Remember the Alamo? All that land you lost to Davy Crockett and Sam Houston? We might help you get it back if you join our side. Once that became public, and it was public, and today it would be 24/7 news, but back then it was printed in all the major newspapers and largely publicized, and it became a cause célèbre. The Zimmerman Memorandum, I won't say annoyed, shocked the Americans into recognizing that war was getting closer to the home base than we thought. And while it turned out not to have much real effect on the war itself, it did have major effect on the United States' feelings towards the war. And as a result of the Zimmerman Memorandum and other factors, 3 months later, we were in the war. Wilson was inaugurated on March 4th, 2017. Back in those days, the inaugurations were in March. They weren't changed to January until after FDR took over. So on March 4th, Wilson was inaugurated. The person who kept, it was campaign slogans, he kept us out of war. And 1 month later, he was asking for a declaration of war before Congress. Congress voted us into the war on April 6, 1917. The vote was rather large, although it wasn't unanimous. The Senate voted 82-6 to enter the war, declaration of war. In the House, the vote was, I won't say closer, but it was 373-50, which I think is somewhat reflective of the fact that 50 members of the House of Representatives, out of then what was a little over 400 votes, roughly close to 10% of the House was either against the war or Americans getting into the war, and that probably reflected public sentiment at the time. One of the 50 who voted against entry into World War I in the United States was a congresswoman named Jeannette Rankin. Jeannette Rankin was at that time the first and only woman member of Congress. Now there's more than 100 of them. And some people say, well, how could she be in Congress if women couldn't vote then? Because they couldn't. The 19th Amendment wasn't passed until sometime afterwards. Well, many states, especially in the West, allowed women to vote and to hold office. And she was from Idaho, and Idaho did allow women to vote and hold office. In Minnesota, women were allowed to vote well before the 19th Amendment was passed. Minnesota, like many of the states kind of west of the Mississippi, had women's suffrage before the 19th Amendment. Women could vote in library elections and school board elections in Minnesota. Couldn't serve, but they couldn't serve on those boards. They could vote for them, but not serve. So Jeannette Rankin was from a state that allowed women to vote and to serve in public office, and she voted against entry into World War I. The significance of her vote among the 50 is Jeannette Rankin was also in Congress on December 8th, 1941, when Franklin Delano Roosevelt stood at the podium there and referred to the events of the previous day as the day of infamy, the day after Pearl Harbor, and he asked for a declaration of war. World War II, Congress voted unanimously in support of entering the war after Pearl Harbor, with one exception, Jeannette Rankin. So she voted against entry into World War II as well, and continued to serve in Congress. She was reelected until she retired in 1948. So that's just a little bit of trivia there. The one person who voted against World War II also voted against World War I. American troops were mobilized quickly, and the troops landed in France within 2 months, which was remarkable because, as you know, we had a very small military force preceding World War I. We had very small number of Marines, a relatively decent-sized Navy because that Navy had been built up during the Spanish-American War, but our military and our Army was relatively small. There were perhaps 100,000 total in the United States military at the time. They spent most of their time chasing Pancho Villa in Mexico. So we did not have a big army. We did institute a draft in 1916. The draft was instituted a year before we got into World War I because we kind of saw the handwriting on the wall, although we were still neutral, but we enacted the draft law in 1916. which was fortunate because had we not had that draft law in effect a year before the war, we could not have mobilized 4.3 million people that quickly. It was a massive undertaking. And likewise in World War II, the draft for World War II was started in 1940. A year before we entered the war, we did institute a draft, again, seeing the kind of handwriting on the wall. And it was fortunate that we did that because if we hadn't had a draft in 1940, we would have had a more difficult time getting people in and quickly getting them in after December 7th, 1941. So the draft existed before in 1916. It is somewhat remarkable that we're able to raise that many troops that quickly and get them abroad that quickly. Within 2 months, get them into the theater of war in France. Not all of them did, but at least we started to get troops over to France in June. And given the the media and technology and the transportation of those days, that was a remarkable technological feat. War went on for 18 more months. The armistice on November 11th, 1918. And then the Treaty of Versailles began, the negotiations for the Treaty of Versailles began shortly afterwards, with Wilson going to Europe to negotiate the Treaty of Versailles. It wasn't formally signed for 5 years later, but for all practical purposes, the major powers signed off on June 28, 1919. So about 7 months after the war ended, the treaty was signed, ending the war officially. Some of the impact of World War I, before we get into the case law of World War I, and this is just some of them, you probably have some other ones in mind too, but the Bolshevik revolution of communism in Russia/Soviet Union arose because of World War I. There were rumblings of dissent and discontent in Russia for many, many years, but it was World War I that precipitated the fall of the Romanov Empire. Lenin, who was who had been an agitator of sorts in Russia for years, had been exiled from Russia. The Germans put him on a train and sent him back to Russia during the war, and he continued his course of raising concerns about the Romanov Empire, and ultimately the fall of Russia occurred in 1917. Storming the Winter Palace, we've seen pictures of movies of that, and the Russian dynasty fell. And as soon as that happened, once the Bolsheviks took power, they immediately withdrew Russia from the war. In fact, that was one of Lenin's platforms, is get us out of the war. The Russians got out of the war in 1917, and ultimately communism took hold there. American isolation was a direct result of World War I. As you know, the Senate defeated the League of Nations, and America retreated into isolationism, which I'll get back to in a minute. The Volstead Amendment, the prohibition law, came about in 1919 after the war. It was promoted by Andrew Volstead. There's a mistake there. He wasn't from Minnetonka. He was from Minnesota. Andrew Volstead was a congressman from Granite Falls, Minnesota. He was the father of the prohibition law, which was enacted in 1919. You all know how that went. And likewise, at the same time, we had another amendment to the Constitution. That's the Women's Suffrage Amendment, 19th Amendment. And incidentally, I said Minnesota women had the right to vote, but Minnesota women were the first women to vote under the 19th Amendment. The day after the 19th Amendment was ratified, August 20th, 1919, there was a bond election in South St. Paul the day after the 19th Amendment went into effect, and women were allowed to vote in that. And the South St. Paul women who voted in 1919 were the first women in the United States to vote under the 19th Amendment. Expatriates abroad, Hemingway, Fitzgerald, Gertrude Stein, that was a movement that occurred after World War I, the Jazz Age. And the rise of Nazi Germany in World War II was attributable in large part to the Treaty of Versailles and the punitive aspects of it that the Germans took offense at. And the inflation that occurred in Germany and the falling apart of the German empire, all of those contributed to the rise of Hitler and Nazism. There were a lot of other contributing factors, but World War I and the way World War I ended and how it ended and the reasons it ended were contributing factors to the rise of Nazism, Hitler, and World War II. And there's a number of other impacts as well. Now let's talk about some of the case law that affected or was affected by World War I. And let me start with the First Amendment, because that's where a lot of the post-World War I action took place in the courts. The concept of clear and present danger, which we all in this room are familiar with, that articulates the boundaries of the First Amendment, came out of World War I cases, and they came out of Minnesota cases in World War I or shortly after World War I. Until these World War I cases, there was hardly any litigation involving the First Amendment, at least at the Supreme Court level and most other federal court levels. If you go back and look and do some research, you will find very few, if any, First Amendment cases. It just wasn't litigated back then. The challenges to governmental authority, local, state, and federal governmental authority, challenges to regulations or laws under the First Amendment just didn't exist. And if we were here 100 years ago and someone was talking about, well, let's challenge that under the First Amendment. They can't do that. That law is unconstitutional under the First Amendment. People would say, well, you can't do that. No one's ever challenged a law under the First Amendment. And with rare exceptions, they were right. There was no body of jurisprudential law of any significance at the federal level dealing with the First Amendment until the cases I'm about to talk about. And they evolved into the clear and present danger case. The concept of the terminology of clear and present danger came from Oliver Wendell Holmes in a concurring opinion in the Schenck versus United States case. That was a World War I case dealing with radicals who opposed World War I and were convicted under statutes that prohibited them from expressing their opposition to World War I. And in the Schenck case, Oliver Wendell Holmes concurred with the holding that the statutes that prohibited speaking out against the war were constitutional. Holmes was affirmed the government's position that it was not unconstitutional to punish war dissenters. But in his concurrence, he uttered the famous clear and present danger line, which became the demarcation point for what constitutes permissible and impermissible suppression of free speech, clear and present danger. That standard was modified a bit in the Brandenburg versus Ohio case, 1969, imminent lawlessness, but the concept is still the same. The boundaries of what is and is not permissible in terms of government regulation of speech is whether the speech that's being regulated poses a significant, substantial, and immediate risk of harm, or as commonly referred to, you can't yell fire in a crowded theater. That comes out of the World War I cases. One of those cases is a Minnesota-related case, Arver versus United States, 1918 case. It was a consolidated case brought against 5 individuals who challenged the 1916 draft. One of them was from Minnesota. They consolidated cases, but a Minnesotan was one of the 5 litigants in the Arver versus United States case challenging the draft that had been instituted in 1916. The challenge was grounded on 3 provisions of the Constitution: the Equal Protection Clause, the Due Process Clause, both in the 14th Amendment, and the 13th Amendment, that it was involuntary servitude, violating the 13th Amendment, the Slavery Clause, the Constitution. The Supreme Court unanimously upheld the 1916 draft despite the protestations of the Minnesotan in the Arver case and others. The court said it was the highest duty of a citizen to participate in the draft and military activities when called upon by his or her country. And the draft, military service, the court said, was inherent in citizenship. So the draft was upheld in 1916. The 1916 draft was upheld in the Arver versus Minnesota case that came in part from Minnesota, but there was another case that came wholly in Minnesota. Minnesota was one of many states that during the war passed state laws that prohibited or restricted taking actions that would interfere with or affect in a negative way the war mobilization effort. The Minnesota law prohibited interfering or disrupting military enlistment. A soldier from Goodhue who had been in the war and then had been undeployed and redeployed after the war. During the war, he was removed from service during the war. He led a protest movement. He was one of the Minnesota protest movement leaders. He came from Goodhue, Minnesota, outside of Red Wing. And one of the tactics used by anti-war people in those days was to surround the draft board offices. There was one main draft board office in downtown Minneapolis at the old federal building, which still stands, and there was one in St. Paul where the Landmark Center is. There also was one at Fort Snelling. And the people who were opposed to the war, and there were a fair number of them, would join together, link arms, stand in front of the draft board's offices to prevent enlistees from entering the draft board or signing up or being mustered into the military. That tactic was one of many that was used in the Vietnam War, of course. It was used in a much lower level. It wasn't as prominent, it wasn't as prevalent, but there were protesters, and they did protest, and they protested in front of the draft boards, among other places. And the protests in World War I were grounded, and there were basically two factions that were opposed to our participation in World War I. There was one faction of what we today would call left-wingers, people who were opposed to the war. The same kind of ideology that was opposed in part to the Vietnam War. They would be, today in terminology, they'd be left-wing. They were opposed to the war. And there was a fair number of them, not anything approaching the numbers of later wars, including Vietnam, but they were sizable. Another sizable group that was opposed to the war wasn't necessarily opposed to war. They were opposed to our joining the Brits in the war, the British and the French, and that is there was a large number of Germans in this country, German immigrants. In fact, the largest number of immigrants in this state come from Germany, and Wisconsin had a large number of German immigrants too. The Midwest, generally Minnesota and Wisconsin had the largest number of German immigrants. They were opposed not so much to the war, they were opposed to our being on Britain's side in the war. So they kind of joined with the people who were against war in general, and they protested the war. Their protest was, we shouldn't have entered the war on Britain's side. There was another group that joined with the Germans, and that was the Irish. And the Irish have age-old conflicts with Britain going back centuries, and they didn't want us to be in the war on Britain's side either. So we had the Germans and Irish on one faction saying, don't be on Britain's side, don't be in this war on the British side. We had another faction of anti-war people who said, let's stay out of the war altogether. And that was the protest movement of its day. Again, dwarfed by protests of the Vietnam War and other wars, but nevertheless, it was the beginnings of protests of the war. It wasn't the first time we had protests of war. There were protests in the Civil War days too, but Civil War protests were largely over the draft laws and people not wanting to be drafted into the Civil War, but there were some other causes too. So the anti-war movement, if you want to call it that, did exist during World War I. Minnesota had this law banning interference or disrupting military enlistment. A good soldier who was no longer in military service, he had been mustered out, was the leader of that, and he was convicted under the Minnesota law. He was convicted of a crime for violating the Minnesota law. The case went all the way up to the Minnesota Supreme Court, and in 1920, 2 years after the war ended, the Supreme Court had the case, had that issue before it, and the issue in that case, for probably the first time, the Arbor case didn't involve the First Amendment. The Arbor draft case involved the 13th and 14th Amendments. This was the first case, the Gilbert case, that directly took the First Amendment into the war theater. And the claim made by the claimant, the defendant, the convicted defendant in the Gilbert case was First Amendment. I have a right to express my views. I was expressing my views against the war. I was taking action to try to prevent people from going into the war. And he claimed the First Amendment protected his right to do so. That reached the Supreme Court, and the Supreme Court voted 7-2 against him and upheld his conviction. The court reasoned that it was a proper exercise of the state's police powers, and that's a concept, we deal with it today. In those days, the concept of police powers was a much larger concept. Today, we see it come up oftentimes in health, welfare, and zoning issues. Back then, police powers was a synonym for the state has power to regulate whatever it wants to regulate, essentially. And there were very few restrictions on state power. So the police powers was the doctrine used to, pardon the expression, trump the First Amendment in that case, and the Gilbert law. It was interesting, there was two strange bedfellows that joined in the dissent. The decision in the Gilbert case rejecting the First Amendment defense was 7-2. The two dissenters were Chief Justice William Howard Taft, and Taft was of the view that there was a preemption issue here, that the state law should be preempted by federal law. Taft was a well-known conservative and very conservative in his judicial outlook. In fact, Taft, when he was placed on the Supreme Court, said, "My one mission is to stop the Bolsheviki in this country." So he was known as a right-wing conservative. I don't think they used the word right-wing back then, but he was a very conservative jurist. And he dissented, saying that the Minnesota state law was preempted by federal law. The other dissenter was Louis Brandeis, the very famous liberal judge, and he dissented on, my gosh, First Amendment grounds. We got a First Amendment problem here, he said. This man's speaking out against the war. He ought not be punished for that. So that was kind of strange that the most conservative justice in the court, probably, maybe not the most, but one, the conservative pillar of the court and the most liberal member of the court in those days, both joined together in opposing the Minnesota law for different reasons. The Gilbert case was a predecessor, a precursor for other more recent cases that we're probably more familiar with. One, of course, is the O'Brien versus United States case, and that's the draft card burning case. And many of us grew up in that era, or certainly remember it or read about it. One of the symbolic efforts to protest the Vietnam War was individuals burning their draft cards. And that was, I won't say a staple, but it was relatively commonplace at Vietnam War protests. Burning men, women back then with draft cards, never anyone with draft cards yet, but men burning their draft cards. They were prosecuted under the federal law that prohibits defacing government property. And the argument there was, well, one argument was a statutory interpretation that it wasn't government property. But a second argument, and the more significant argument, is First Amendment. Symbolic speech, holding up a burning draft card. 20 years later, the court said burning a flag is constitutionally permissible. But in '68, the issue was whether the First Amendment protects someone from criminal prosecution for burning a draft card. And the court relied upon the Gilbert case in upholding the draft card burning law and upholding the convictions. The court ruled on two grounds in O'Brien. One element of the O'Brien case was that a draft card's government property. It's issued to you, but the government owns your draft card. It's kind of like your mailbox. The government has a proprietary interest in the draft card, or a piece of paper. But the second and more significant part of the O'Brien case relied upon Gilbert. The First Amendment does not permit that kind of activity when it's antithetical to war efforts or draft-related efforts. A couple of other cases that stem from Gilbert versus Minnesota was the Rosker case. The Rosker case was another Supreme Court case in 1981 that upheld the all-male draft. The all-male draft, that was not argued on First Amendment grounds, it was argued on equal protection grounds, but the court went back to the Gilbert case and used the concept of police powers and the virtually impervious position of the government when dealing with draft-related issues. And that's because of the Gilbert case. And lastly, a case that strikes home here, the Emperor case. That's a case in the early 1980s. By that time, of course, well, since the mid-70s, there had been no draft. The draft had been abolished, but the selective service system still required, and still does, men, when they reach 18, to register with the selective service, even though there's no draft. That law has been in the books for almost 35 years. And the requirement is that when a man who turns 18 has to register with selective service. In the event we do reinstitute the draft. The punishment for not, for not registering, giving your name and address with the selective service, the punishment is, or one of the punishments, federal crime, but one of the punishments is no federal student aid can be given to an individual who doesn't register with selective service. So the punishment was, if you don't register for selective service, you can't get federal student aid, scholarship money, and anything that comes from the federal government. That was challenged, not under the First Amendment, that was challenged largely under the Fifth Amendment as self-incrimination, a violation of the self-incrimination clause, as well as due process and equal protection. So there are a number of constitutional claims, and Judge Alsop here in Minnesota upheld the challenge, which was brought by MPIRG, that's the Public Interest Research Group at the University of Minnesota. They were the named plaintiff in the case, but it was brought on behalf of men who objected to registering for selective service. Judge Alsop upheld their contention and ruled that the provision of the federal law barring financial aid for non-registrants was unconstitutional. That went up to the Supreme Court, and it was overturned. The Supreme Court overturned that and upheld the prohibition of financial aid to non-registrants for selective service, and they upheld the Supreme Court upheld that largely on the Gilbert versus Minnesota precedent for Minnesota. There's a number of other Minnesota cases which are discussed in the article that was handed out, dealing with the same kind of Gilbert issues. Anti-war pamphleting was fairly profuse during that 1916, 17, 18 period of time. That was another major form of protest. Again, no social media, no internet, no text, no Instagram. So pamphlets were distributed largely in the metropolitan areas, but in other areas too. Pamphlets were distributed against the war. and the pamphlets had titles such as "The War is Coming," "We Are on the Wrong Side," "It's a Rich Man's War," theme that reverberated in Vietnam too. These pamphlets were short, they were small pamphlets, sometimes they were just flyers, but they expressed opposition to the war in general, and sometimes went even further than that and challenged the government's participation in the war. One well-known pamphlet at the time was called Make Democracy Safe for Democracy. One of the slogans of World War I was "Make the World Safe for Democracy." Some of the protesters of the war had this other theme that says "Make Democracy Safe for Democracy," claiming that the war was anti-democratic. Those were the kind of pamphlets that were distributed throughout the country, but there were several, but they also were distributed heavily in Minnesota, and several cases were brought against those individuals under the same law that I've been talking about. And there were a couple other related laws. There were anti-war laws that were passed, and almost all those cases resulted in upholding convictions for passing out anti-war pamphlets. Fortunately or unfortunately, depending upon what your viewpoint is, that precedent didn't crop up again during the Vietnam era. And the notion that state or federal laws can prohibit people from opposing the war if they're not taking any detrimental action to the troops is probably passé, but it's an interesting period piece that the courts were generally upholding state suppression laws dealing with anti-war sentiment. Here in Minnesota, back in those days, we had something called the Committee for Public Safety. The Committee for Public Safety was a high-level, semi-official government agency headed by the governor himself, and with private citizens as well. This was in the period of the war, 1916, 17, 18. And their job was to find people who dissented from the war and make sure that their voices weren't heard. That was called the Committee of Public Safety. It was a semi-official state body run by the governor of Minnesota. And one thing they did is they published in the newspapers the names of people who were anti-war and said, these are the people, do what you want with them, but don't frequent their businesses, don't let them, don't let them enroll in your universities and colleges. And it was fairly prevalent here, and that was a way of fighting back, if you will, the anti-war sentiment that existed here. One more case I want to talk about in this context that's kind of interesting, and this is a civil case, not a criminal case. This case comes out of Laverne, Minnesota, southwestern part of the state, as you know. And that was another, I won't say hotbed, but that was another main area of opposition to the war. A lot of German heritage in the southwestern part of Minnesota, near New Ulm, Herman the German. And there was an individual there who was known as kind of the head of the anti-war movement. He wasn't a left-wing protester. He was a German who was against American involvement in the war on the British side. But he wasn't well liked in some portions of that community. He was tarred and feathered, and the law enforcement authorities stood by and watched the citizens tar and feather him. It's a little bit like a public hanging event, a public hanging type of incident. And the authorities there allowed it to go on. The authorities didn't undertake it, but they condoned this person essentially being run out of town because he didn't support the war. He brought a civil lawsuit against the authorities and against the people who tarred and feathered him. And that case went up to the 8th Circuit. His case was thrown out by the federal court here in Minnesota on the defense of justification. The main defense in the case promulgated by the defendants in that civil case was we were justified in doing this. This guy was anti-war. He was whipping up a lot of anti-war fervor. He was telling people not to support the war, so we were justified in tarring and feathering him and running out of town. The federal court here in Minnesota upheld that defense and dismissed the civil lawsuit. It went up to the 8th Circuit, and the 8th Circuit reversed. You can't have a defense of justification for essentially committing a civil assault against someone who hasn't done anything criminally wrong. Don't know what happened to the case afterwards. It was remanded and probably lost in the bowels of history, but that's an interesting civil aspect of the anti-war ferment that existed. I don't mean to suggest here that it was the anti-war ferment was anywhere near as much as it was in some of our more recent wars, including Vietnam, but it did exist, and it was the foundation for these First Amendment cases that have stood the test of time and essentially formed the legal doctrine of our First Amendment jurisprudence in the last century. I want to move on to some insurance-related issues because insurance became an issue during World War I. Until World War I, there was no concept of health insurance. It didn't exist. There was no health insurance. It just was an alien concept. You ask someone back then, who's your insurance carrier? They'd say, my what? They may have property insurance and maybe automobile insurance, although there wasn't much of that either. But health insurance didn't exist before World War I. Likewise, life insurance did exist, but it was very sparse. The people who had life insurance were big business magnates and very wealthy people. Life insurance was not a commodity that people had back then, and no one had health insurance. The reason they didn't have health insurance is because it didn't exist. It began in World War I. In 1914, Congress passed the War Risk Insurance Act. Now, this is before we got in the war, but we recognize that at some point we may get embroiled in this war, not knowing what side we'd be on. And our troops, our military forces, as I indicated, were very small. And as an inducement to get people, men, to sign up for the military, they got insurance. They got health insurance and life insurance. So as part of the sign-up bonus, to sign up for the military, pre-draft, you get insurance. And they invented health insurance. The health insurance was essentially through what was then the military, and VA didn't come into force until afterwards. But you get health insurance and life insurance if you join the Army or Navy or Marines. There wasn't no Air Force. And so also all members of the military service during the war received health insurance and life insurance. And they can, after the war ended, the government, there was paid health insurance and paid life insurance. The government paid for it. The insurers did not have to pay any premiums until after the war ended. When the war ended, they could continue the policies in effect, but there was one problem there. They had to pay the premiums. The term we use today is converting. Can I convert my life insurance? Can I take my health insurance? Is it portable? Well, it was in a sense. They could continue to maintain their health insurance and life insurance provided they paid the premiums. Well, people weren't familiar with the concept of paying premiums for insurance because they weren't familiar with insurance. So many soldiers, military people, kept the insurance, but they didn't pay the premiums, or let's say they thought they kept their insurance. And the insurance insured it was a life insurance. It also provided health insurance for service-related injuries, service-related deaths. They had to show that there was some relationship to the military service. And as the years evolved, or years passed, in the 20s, into the early 20s and later on, many of the service people either died or incurred what they claimed was service-related afflictions. Trauma from the war, injuries and afflictions from the gas attacks in the war. Some of these injuries didn't manifest themselves for several years, and they then made claims under their insurance policies. But none of them had paid the insurance premiums. So the question was, can they retroactively invoke their insurance policies that were dormant because they hadn't paid their insurance? And these are all Minnesota cases that went up to the 8th Circuit dealing with that issue. One case, the leading case was Stevens versus United States. And there the court held that the insurance policies cannot be retroactively reanimated after they lapsed due to non-payment. And the fear was that, they said the fear was fraud. We're afraid that people are going to be fraudulent and bringing these late blooming claims here. And the 8th Circuit ruled that the insurance policies, if they hadn't been kept in force, were no longer applicable. Fairly common concept today. If you don't pay your insurance policy, you can't keep it in force. However, there were some exceptions made, and I note a couple of exceptions here. If there was what the court referred to as a total permanent disability, if an individual could prove that they were totally and permanently disabled because of war-related service, the court said that the policies must cover them even if they didn't pay the premiums, provided they go back and pick up the premiums. Kind of like going back and picking up your CLE credits after you've been off the register for a while. So the court said if there's permanent and total disability, we will recognize the validity of those policies provided that the service members or their family go back and pay all the premiums that have accrued while they've been permanently and totally disabled. And that became that became the law as it existed back in the 1920s. That concept has morphed a little bit into something we're more familiar with today. It's something we heard a lot about during the election campaign. Pre-existing conditions. Anyone heard that phrase uttered recently? That's a birth of pre-existing conditions. It's not exactly equivalent, but the concept is the same. If you can show that you have some pre-existing condition, the insurance ought to cover you. And that's essentially what the court was saying in a different way, talking about retroactivity and lapsing back in the 1920s. There was another aspect of the war insurance here in the Minnesota cases and cases around the country that also still is in effect today. Those policies, especially the disability policies and the health policies back then that were issued to all servicemen and became the subject of Minnesota and Eighth Circuit related litigation, were the predecessor for the Social Security laws of the 1930s. The New Deal Social Security laws were conceived and predicated on the concept of insuring people for disability. As you know, Social Security has two main elements. One is pensions for older people, but there's another element, which is disability pay for people who are disabled or their family members. And it's the concept of Social Security, which was enacted in 1935, New Deal era, came from these World War I insurance policies and the litigation that it spawned in the Eighth Circuit. And the Social Security system, in part, is attributable to these cases. That's the same Social Security system we have today. Historical footnote, the concept of Social Security or providing government payments for the elderly, retiree, and pension payments came from where? The concept of Social Security, not in this country, but it was born in Germany in the 1880s. Germany introduced Social Security. They didn't call it that, but the concept of Social Security comes from Germany, and it was introduced by Bismarck I, whose son, Bismarck II, was the one who was involved in World War II and his abdication right before the armistice. So 6 degrees of separation there. Another type of litigation that's attributable to World War II, World War I, oops, I'm in the wrong era, is described in a case called Hall versus Davis. Back in the government nationalized the railroads during World War I. The railroads were essential to the war effort. No planes, no planes carrying transportation, no planes carrying freight where it existed back then. And the only way to get goods, especially the troops, mainly food from the Midwest, the main way to get food from the Midwest out to the troops fighting in France and in Europe was to put it on railroad cars and send it out to the East Coast and then transport it across the ocean. Much of that came from the Midwest. There was the particular forest fire that happened here was in 1918. That was a nationalized railroad bringing food, grain, and the like from the Midwest through Minnesota up to Duluth, where it was going to be put in ships there and then brought across the sea to Europe. The railroad system was poorly run by the government, to say the least. Government was not in the business of running railroads, and they didn't do a very good job. They had a lot of old railroads, old locomotives. They didn't have the right people running them because many of the people who would have been engineers and on the railroads were in the service. So the railroad system was not well run during World War I, which is why during World War II we did not nationalize the railroad. But in World War I we did, and it led to a forest fire. A locomotive taking this grain up to Duluth caught fire outside of Hinckley and created a huge fire. We'll talk about fires in a minute. This is right outside of Hinckley, essentially where Highway 35W is now going up to Duluth near Toby's there. Don't confuse this with the Great Hinckley Fire of 1895. There is a fire museum in Hinckley that commemorates the Great Hinckley Fire of 1895. This isn't the 1895 fire, this is the 1918 fire, caused by a defective railroad car and a defective rail track because of government malfeasance. A fire started and it was huge, as you can see, 2,000 square miles right in the Hinckley area, $40 million of property losses. That was a lot of money back then, and 500 deaths. Compare that to what we're unfortunately witnessing now in California. There's 30 deaths in that fire in California, and the Hinckley fire was 500 deaths. Right? Almost 20 times the number of deaths we're seeing in that huge California fire. So you can imagine what that fire must have looked like and how big it was and how immense it was. Well, it led to litigation, and there were some 278 claims that ended up in the court system. Some of the claims are probably settled and resolved or weren't even brought, but there was a total of 278 claims that ended up in the Minnesota court system as a result of that fire. And the claims were then consolidated in a case called Hall versus Davis. And it probably was the first time in the annals of American jurisprudence that a large number of claims, some small claims and some large claims. The large claims generally were brought separately because they were big enough, but these were mainly smaller claims. A large number of relatively small claims were consolidated together for the first time in American history because of this forest fire in Hinckley due to the defective rail car in World War I. They were, back then, they didn't have the same name we have for today. They consolidated the cases. Today, that practice of taking a lot of small claims that arise out of the same occurrence and are typical is called a class action. This was the birth of class actions. Next time you're driving up to Duluth, you stop at Hinckley there, recognize that that's the birthplace of class action. Right? Hinckley does have the museum, the fire museum in Hinckley, but they all probably ought to have the class action museum in Hinckley because that's where class actions were born because of that case. Finally, in conclusion, I want to talk about a couple of business cases that raise a conundrum that we've all probably addressed in first-year law school class, and that is, to what extent can a contractual or business relationship be altered or changed because of circumstances that arise after the original transaction? And World War I bred a few of those cases, and they're discussed in that article. I just want to focus on one right now, and that's the Minneapolis Gas and Light case versus City of Minneapolis. Back in those days, the Minneapolis Gas and Light Company was the predecessor of what later became known as Mini-Gasco and Northern States Power and all those utility companies. Back in those days, the utility companies contracted with the city to provide utility services to the residents of the city. And the residents of the city, or the landlords of the businesses, they'd be taxed on that, and they'd pay the utility bills to the city, which was essentially the intermediary. City would contract with the provider would provide the utility services to businesses and homes and landlords and whatever facilities there were. Those facilities then would be taxed by the city. They'd get their utility bills from the city, like water bills today, city bills for water. But in those days, the city billed for all utilities. So the city had a fixed price contract arrangement with Mini-Gasco back in 1914. It was a 5-year contract that said, this is what we'll supply the city with utilities, gas service, electric service to the city. The city will pay us a specific specified amount, and then the city will collect that from its residents. Well, pretty typical. But then came the war. And as a result of World War I, the gas and other materials necessary for the utility companies to provide the utilities increased exponentially. The costs went up through the roof. And the gas company, the utility company, went back to the city and said, we have to change this contract here. We're getting killed on this thing. Our costs have just mounted significantly because of the war. And so you understand that. So we have to increase our charges to you, City of Minneapolis, and you, City of Minneapolis, and can pass it on to the recipients of the utility services. The city resisted that and said, no, we're not going to change our fixed price contract. A deal's a deal. That ended up in litigation, and the case went up to the Minnesota Supreme Court, and the question was, can a contract be modified or changed or altered because of developments that happen after the contract is entered into? We call it today, and not just in contract law, we see it in family law and other areas of law, change of circumstances. To what extent can a relationship that exists in the law, a legal relationship, be it a contract or some other relationship, be altered or modified or changed because new developments occur that make that arrangement no longer fair or equitable or just. And that largely turns on whether these ensuing events are unforeseeable or not. And in this case, the court ruled, the Minnesota Supreme Court upheld the contract, ruled against the utility company, and said, you're not allowed to increase your prices on a fixed price contract simply because your costs went up. You should have foreseen that. That's a risk that's inherent in the contract process. If your costs would have gone down, you would have profited more. The fact your costs went up, you have to bear the burden. The other party to a contract does not have to bear the burden of your costs going up. That's a business risk that you took. And the utility company said, yeah, but who knew that a war was going to break out? And the court said, well, that's part of, circumstances that exist. You may have been able to foresee the war, and even if you couldn't, we're not going to let you out of a contract for events that occurred that were perhaps beyond your control, but maybe within the realm of a business risk. That doctrine of the Minneapolis Gas and Light Company, which existed in earlier cases too, was consecrated in the Minneapolis Gas and Light Company case, and essentially stands for the proposition that for a change in circumstances that's significant and substantial, that results in a change of business relationships, must be substantial, it must be significant, and it has to be unforeseen and unforeseeable. The mere fact that one party to a contract or other relationship has a change in circumstances isn't enough to alter the relationship unless there's an unforeseen change in circumstances. And that stems from the Minneapolis Gas and Light Company case, although that legal doctrine was around before, but it comes through very vividly in this case and some of these others that I talk about. Well, that's kind of a quick overview of some of the Minnesota cases that affected World War I or were affected by World War I. And I appreciate the opportunity to speak to you about it. And if anyone has any questions, comments, or criticisms, preferably not too many criticisms, I'll be happy to entertain those. For those of you who have been in the military service or have relatives or others relationships in the military service, thank you and thank them for their service, and thank you for your patience and time listening to me today. Thank you. Okay. Okay.